Hello, it's Philip Taylor speaking from Richmond Green Chambers. I'm looking at a book from Thomson Reuters in the Sweden Maxwell area. It's this heavy one, just over 1,000 pages long, called The European Private International Law of Obligations, now in a third edition, written by Mr. Justice Plender and Michael Wilderspin. Richard Plender obviously had to take time off to produce this because as a new third edition it's undergone a complete rewrite. I've produced again a detailed review on Flickr, and this review will appear on YouTube and all the other internet sites which take this sort of material. Can I just say that the book itself is heavy both in terms of weight and content. There's an extremely useful index at the back, a legal taxonomy. You've also got the usual stuff at the front, a huge amount of information about cases, and then the book itself has the normal type of referencing on the sides, which I'm sure you will all find extremely helpful. It is very detailed. I obviously have an interest in this because my bar finals were devoted to the early years, because I'm obviously a little bit older now, to the early years of the development of what was the old European Community, now the European Union. A bit more about that in a minute. Let me tell you about this review, which I've written with my wife Elizabeth. We've given it the title, having racked our brains to try to think what we could say about this that wouldn't be too heavy, and we've given it the title, The Rome I and Rome II Regulations. Get the full picture of their legal position, their interpretation and application. And putting it in Euro speak, that gives you some idea of what you're up against, because obviously what we're looking at here, when we talk about the law of obligations in the private setting, we're talking about contract and tort specifically, but we're also looking at the mixing within the European context of the way in which we're going to view obligations of the parties in the future. So what we're saying then is, if you are a practitioner or a learner, student, dealing with or planning to deal with cross-border or global business, which of course increasingly is just about all of us today, you'll find this book an extremely useful reference to have on your shelf, as long as you've got a strong shelf, because it is heavy. It's logically structured in 3 parts and written in accessible English, and we say that this important text does what it says in the title. It guides you through the complexities of what is now termed the European Private International Law of Obligations. Now, I know for newer students, learners, whatever you want to call them, newer members of the 2 parts of the profession, you will be more aware of what the law of obligations means in, say, a studying sense, rather than some of us older practitioners who look much more at the substantive law areas. But let's have a look at some examples of what this book does. Let's give one amongst thousands. Which country's laws should be applied in any given cross-border relationship or transaction, and in what circumstances? Now that's a sort of question that's been cropping up for a long time. It actually, in my view, gets to the heart of the membership of the European Union and what we want out of it. And of course a lot of people see that what we want out of it is actually more cooperation, although there are some of course who wish to leave completely. And that's just going to make life, frankly, a great deal more difficult, which is one of the reasons why just about every syllabus today has European Union law as a compulsory subject. Let's take an example, which I think is quite a useful one. In the case of, say, an English worker employed by a Dutch company on an oil rig in Nigerian territorial waters, injured by the negligence of a fellow employee, which system of law is going to be applicable? No, this is not a question from the Open University or any of those confounded European papers which you will have seen when you were looking or having to do any of this sort of work. purely academically. You can see the sort of problems because they're very real problems for people like myself as practitioners. So what is the problem? And what are the judgments in this case? Obviously what you need to do is have some idea, because judgments have been particularly criticised by some, which is why one of the book's most intriguing chapters is actually entitled "The Country Whose Law is to be Applied." I'm not going to find it now, but you can find it in the book, and you can see again the sort of problems that we are encountering. Let me just go back a bit now to the preface and the germination of this book. The book's original title for its first 2 editions was The European Contracts Convention, the Rome Convention on the Law Applicable to Contracts. As the preface explains, the new title was made necessary for this new 3rd edition by the development of case law on the Convention, both at national level and within the Court of Justice. That's the European Court of Justice. The authors, Mr. Justice Plender and Michael Wilderspin, were careful to prepare the new edition only after the conversion of the Rome Convention into a regulation and the entry into force of the parallel regulation of the law applicable to non-contractual obligations. So we think that the new title better describes the wider compass of the work, which will certainly help you interpret, apply and advise on both Rome I and Rome II regulations. Of course, to be expected with the excellent Sweet and Maxwell series, you've got expert commentary provided throughout on the scope, principles and application of the rules of private international law governing the construction of contracts. Now, there are lots of other publications available, but remember what this aim is. It's about the European PIL obligations element. So remember, you've got plenty of other books you can cross-refer to if you want to from the Sweet and Maxwell library. Also covered are the new rules governing tort, including product liability, particularly relevant of course, liability for breach of competition rules, environmental damage, unjust enrichment, and various other things such as negiotorum gestio and culpa in contrahendo. Now I'm using those, I hope, in the correct terms, but we all have our own ways of pronouncing these things. Obviously consumer contracts, employment contracts, mandatory rules, etc. are more deeply considered as well. And for ease of reference, there are 10 tables of cases, including UK and foreign cases, cases before the ECJ, both numerical and alphabetical, which of course is quite helpful when you're trying to find them. Remember, of course, Gray's Inn Library has the expert stuff when it comes to much of the European publications information at the moment. You've also got tables of international court and tribunal cases and tables of UK statutes and statutory instruments, which of course is very helpful. Foreign statutes are also included, and there are tables of EC legislation and international and EC treaties and conventions, plus a table of principal conventions, all of which is there as an ease for reference. And of course it does make it a bit heavy in as I say, both senses of the word. So to conclude, for all those involved in or advising upon cross-border issues within the European Union, this book is indispensable, in our view, for both, whether you want to call them EC or EU lawyers. I tend to put them all together. I know there's perhaps a semantic difference, but it's certainly applicable to those involved in this area of law for the 21st century as we grapple with the wider compass of legal obligations in Europe. And I think we must thank Mr. Justice Plender in particular for the huge amount of knowledge and experience which he and his colleague Mr. Wilderspin have put in. And also thanks of course to Thomson Reuters. Thank you very much. Bye bye.